Well, first you can see I'm nervous. Because I'm one of those bad advocates put at the end after all the good ones have spoken, so that if I mess up the case...
That is not true, we will decide.
So, I'm going to be brief for two reasons. One is that we align ourselves with the legal points that have been made, the reliance on the Logbro case, the reliance on a number of cases that indicate that a process doesn't have to be perfect.
And whatever the choice was, which choice was made between different options,
yes,
it might not be the best option. The court might think there's a better option, but that's not relevant.
It never is the best option, because these choices are choices about what I call decisions about the human condition, disputes between people. So what we...
Is that a concession? It is not the best option.
I'll tell you at the end what my best option is for transformation. It's not the best option.
Mm-hmm.
Yes. The first point that I think needs to be made is that the difference between the role of the judges and that of advocates, particularly in a case like this, what distinguishes you from us is this: we want to win the case and maybe earn some fees. Judges sit above us, have a bigger and better responsibility to pass judgment on the paradoxes and complexities of disputes between human beings, between structures, between classes, between council yesterday. We don't have to repeat what has been said. Two, I will be brief because South Africans have a dubious relationship with truth. That is why they cringe when we tell the truth. And so I'll be brief because I do not want to burden the court with that. I want to rely for the point, the only legal point we want to make is the point about what should the court use to interpret a statute or a legal instrument. My learned friend talked about form over substance. And I want to take the justices to a number of cases. One of them is the Van Heerden case. I think it's paragraph 31 to 34. I do not have to read it, but it tells us this: that in assessing what decision must be made and whether form must be chosen over substance, judges must look at the materiality of any irregularity on the side of form against the importance of what is the substance. Now, I'm happy that the applicants start like everyone. We like transformation, but people always say, I'm not a racist, but, or I'm not a sexist, but. Usually what comes after but negates the first sentence. And Van Heerden tells us that we have to then, as judges, look at what form, what is the context within which judges must apply those principles. And the cases that I wanted to look at are cases that are real, but one of them is fictitious. Because it's an old 1949 warning by a philosopher to judges deciding on matters of form and substance. And I'm going to add to that an Indian Supreme Court case that I think should be read the world over by judges who believe that their role is not to be legal positivists looking at the mechanics of law, but arbiters of disputes in society, and usually societies that include classes and races that have been subjugated for centuries. And that is the role you have today. And that, by the way, I want to preface this quote from this judge by this: marginalization and exclusion, which are the subject of this case, lead to social death and mental disintegration, the same way physical starvation leads to death. And if you do not realize that the people are full in this court mostly are black, they are here because this case is an existential case for them. It's not a case about mechanics. For many it is, but for them it is not. It's a case about existence and living in dignity. For someone who's white, who's been privileged, it's a case about mechanics sometimes. It's like a man dealing with problems of women. Men usually deal with the issues of sexism with some casualty because they are not the ones who bear the brunt. And so this case that I'm going to quote is a statement made, and it quotes 4 judges. It's a fictitious case, so no one should accuse me that I quoted a case that doesn't exist. It does not exist. And this case was actually created by a philosopher who was facing judges that refuse to assist society in resolving problems that are much bigger than mechanics. And it was about people who were trapped in a cave. And these people trapped in a cave could not come out. And at some point had to cast lots about what they would eat. And they chose at some point that because there was no food, they would cast lot about who between them would be eaten. And they did cast the lots. And one of them, of course, unfortunately, had to be eaten. And there are 4 judges in that story by this philosopher. It's Judge Trapani, Judge Forster, Judge Keane, and Judge Handy. And all of them, like all our judges, particularly in South Africa, are legal positivists. Mechanical about law and principles and what must be applied, sometimes at the expense of the human condition. And of course, they were to face the death penalty. And one judge who's a legal positivist, like most South African judges, said, we have to follow the law. They killed somebody, and they must face the death penalty. That's Judge Trapani. Judge Forster, who argued differently, who saw law the way I would like to persuade you to see it, was a man who relied largely on natural law and not form over substance. He stated this to the other judges. What was exactly the purpose what made those people in the cave, each one of them? Is it possible for us to apply the law in the condition of people who ate one of them because the conditions were conditions of indignity and starvation? And he wanted to acquit them. The other one, like most South African judges, the legal positivist, said no, the law is the law. We have to convict them and sentence them to death. That was Judge Keane. The last one, Judge Handy. I hope no one is that in the room. He was a pragmatist. And he said he could not decide between what was right legally and mechanically and the demands of human dignity. And so he decided to withdraw from the case. Now, what does this tell us? It tells us that the purposive interpretation of statutes and legal instruments demands that judges must rise above the mechanics and measure the form, no matter how incorrect, against the problem in society that they must resolve. It cannot be perfect. The Logbrook case tells us that, not in so many philosophical ways as I've tried, but it tells us that you have to assess whether the imperfect process is material enough for you to sacrifice humanity.
Who is the philosopher?
It's L. Lol. It's a bad name, but it's F. Lol, yes. Not Lol in the meme, but I will give you because he even creates a name for the judgment and the code. But it's a 1949 story that he was trying to tell judges that they are not lawyers, they are not super lawyers, they are far above that. They are arbiters of the paradoxes of the human condition. And it is what I'm asking the court to do, is that in interpreting the legal instruments that we have, no matter how imperfect you may have perceived the process to be, I don't think it was imperfect. There may have been irregularities or things that we don't prefer. But here is what we are facing, is the statistics that was read before you, that with the generic codes having been there for some time, the statistics in South Africa remain that where the reality is that there are fewer women in the profession. The attrition rate is high. In this room, there is no black female senior counsel. In this room, it's not because they are not talented. And that is what you're dealing with. The statistics demonstrate to you that there has been a deliberate exclusion of a particular race by people who tell you that 7 years or 5 years is a long time. These are people and firms that have lived excluding black people and women for tens and hundreds of years. It is therefore incumbent upon the judges interpreting these instruments, the statement, the code itself, and the BEE Act, to say, what would you choose? To condone some imperfection and sacrifice humanity and its problems in the profession, or to condone any irregularity that you find on the principle of the Logbrook case, so that the bigger picture should work. In the other case that I suggested that we should look at, this case is actually a case from the Indian Supreme Court. And it's about how should we apply the purposive interpretation of a statute. I wrote it in the black book because it tells us something that's similar to what Lon Fuller. It's Lon Fuller, the philosophy of justice. Lon Fuller. But let me just say what he said. Because where he uses the word stupid next to the word judges, take no offense, it's him. He was an impolite man. Foster J, the one I talked about, the one I wish you to be, in this case, he expressed better the idea of statutory interpretation by a judge who knows society and their role, and who knows what a judiciary should do, and the importance of internalizing the purpose of the legislation. He said the judiciary is a servant of legislation and its purpose. Then he says, no superior wants, I quote, no superior wants a servant who lacks the capacity to read between the lines. The stupidest housemaid knows that when the boss tells her to drop everything and come running, the boss has overlooked a couple of things. He has overlooked the possibility that the housemaid is at the moment in the act of rescuing the baby from the rain barrel. Surely, we have the right to expect the same modicum of intelligence from the judiciary when interpreting statutes. The correction of errors or oversight is not to supplant the will, but to make that will effective. It is in that spirit that the code, the BE Act, must be interpreted. I do not want to bore you with the context, because the context is obvious. The context is obvious because one has to look at the other case I thought we should look at without reading it, is that the Van Heerden case is important in this context because it tells us what to judge against form. Well, the applicants come to court to complain, maybe legitimately, but a couple of things that were not done, some suggestions that the minister either can't read or didn't read. The fact of the matter is this, is that the statistics that the code is dealing with demonstrate a reality that all of us cringe when it's spoken or do not want to talk about. We cringe because, as I said, we have a dubious relationship with uncomfortable truths as South Africans. But the truth faces us in the face. It stares us in the face. That these firms want to double dip. Double dip because why? They are called the Big Five. Okay, Cliff Decker is not here, and then good for them. Because I think they can see the hypocrisy. All over the world, the so-called top 5 or top 10 law firms are first preferred by listed companies in the stock exchange. They are the only ones. In the South African context, it's the same, except that they are also preferred by the government's parastatals. And so I call it double dipping because to the exclusion of black people and women, indigenous people of this country, these firms who can opt out want to be briefed by the state the same way they are briefed by the private sector. And black people, black professionals, have no stake in both, including the black government. Because the reason this code is put here, which is not radical enough to say, I'm not accusing government, all I'm saying is that the reason government has codes like this, including BEE, it's because it actually wants to brief this minority of white firms. And it tells them, please have a sprinkle of black people with you so that we can brief you. Because the government itself, as black as it is, suffers from what I call epistemic dependency on whiteness, in that it cannot brief its own people. And it has to be forced by people who don't want to change. And what does it do? Black lawyers, like their parents and their grandparents, have to remain beggars even when there is a government that could easily take the billions and give it to them, because their state has a dubious relationship with white power. We shouldn't be here if the government, if the DTIC was committed to empowering the people that are in this room who are black. And by the way, someone even said, and this is the reality of this case, that it's good that we're all black here. Well, it's not good. It's not good because sometimes when white power wants to conceal its purpose, it hires us, right? Someone said in a few months' time, it's good that we are all here. My lady, I want you to look at a commercial or competition case about mergers and acquisitions in a few weeks' time. And you will see what the white firms that are here will do. There will be white males sitting in the rooms, the ones they do not need when they want to project the image of transformation. This demonstrates the hypocrisy that our judges must see through if they are not legal positivists. if they can distinguish between substance and form. And substance, in this matter, substance is whether you believe that the black condition which has existed for the past 500 years is something to stop. That is what a judge does. A judge is not a super lawyer. A judge sits above us because they can compare the paradoxes that exist in society. We are not that big. We are selfish. Because we're human beings, we're not judges. And so in this case, we ask that the judges must choose between one or two irregularities that may have happened in the process and what I think is an existential question for a number of people who may leave the profession soon. I kid you not. The white firms are being briefed. We are here because as black people, we are in no man's land. The white world, which has money, doesn't want us. It has a dubious relationship with our leaders who don't want us. They brief them and create some code for them to accommodate. It's like someone who steals your car and says, well, you know what, I will actually give you a lift over time. That is the South African condition for a black professional, a black person. And that is the context that I think in the purposive interpretation of these codes, you must do what the Indian Supreme Court judges have done because they've been brave enough to understand that being a judge is descending to the very decisions, philosophical outlook of society that produce discrimination, that produce feelings of inferiority.
So form will perpetuate.
Form
will perpetuate.
Form can perpetuate the condition. But you are called judges because you're better than us. You are called judges because you do not have to entertain the idiosyncrasies of human beings. You have to rise above those idiosyncrasies and choices that these firms just want to make money. Maybe some of us just want to make money. But your job as a judge, judging disputes between society, is first to accept. None of you can deny that black people have had a tough time. It doesn't matter. They have a tough time for 500 years and they have a tough time today. And what you need to do in your purposive interpretation is to look at what Section 9 in the Constitution is about. It's about equality. Section 10 is about dignity. And if you're satisfied that black people and black professionals have had a life of dignity in the past and now, well, you have to find in favor of the applicants. But if you believe that the plight that Section 9 and 10 about dignity, those provisions are more important than the mechanics of decision making, you shall have risen above what judges do. I want to leave you with what a judge, Pius Langa, said. He died and left all of you as judges with one paragraph. And this paragraph is about you being courageous. And he said this, by the way, in his last lecture before he died. And he was talking about judges who are brave enough, not just to dissent from another judge or a panel, but judges who are brave enough to take causes that may be unpopular. He says about a dissenter, and I hope you are dissenters. He says sometimes it takes a dissenter to change the course of history. Sometimes the dissenter, like Galileo, is disliked and frowned upon. But it is the dissenter that moves society forward. It may well be that we are in a court where judges will heed that call and look at the statistics against the mechanics, and look at the arguments by people who simply want wealth accumulation for a few, and others who are simply asking to be accommodated. That is the purposive interpretation we must adopt. And I ask that you dismiss this application, not because it's not legitimate, because it fails to appreciate exactly what are the big issues, what is the black condition, what is the condition of the black professional, compared to the mechanics that they raised. And this court, which I think this case is the most important we've had in a long time, it may look small, is that you are asked here to take decisions either in favor of people who have never known dignity, or in favor of people who want wealth accumulation only for themselves. And the reason there are disputes like this in life about human rights and freedom of trade, the reason we are in court every day about rights, justice, presiding, is one reason. It's not because we interpret rights differently. It's not because judges don't understand rights or lawyers don't understand rights or clients don't. The reason there are disputes about human rights, it's because we've not resolved the dispute about who's human. That is what we are here about, is that there are people, largely these 4 white firms, who believe that they have an entitlement to good life, dignity and wealth accumulation at the expense of women and black people. That is the truth we have to face, and that is what I'm asking you to apply in your purposive interpretation. There are corpses, living corpses, who have come out from these firms, even amongst you judges, who've had a tough life with these firms that are white, whose culture is white, that do not see human beings who are black as people with feelings, that have ambitions to live a life of dignity. That's what this case is about.
Thank you, Mrs. Kokona. And Mrs. Kokona? Mrs. Kokona, may I have that little black book?
It does contain a list of people who are spies.